Hello students, welcome you all for the course of MBA Semester 3 Human Relations and Legal Framework. Today is our lecture number 25 and the topic of our today's discussion is Payment of Gratuity Act 1972. So, the objective of our today's session is help to understand the concept of Payment of Gratuity Act 1972 and its various provisions. The contents of our today's session are Introduction to Payment of Gratuity Act 1972, Applicability to Payment of Gratuity Act 1972, short formed as PGA 1972, when is gratuity payable, and definitions under the PGA 1972. So, first of all, we are going to start our discussion from Introduction to Payment of Gratuity Act 1972. This kind of act has been applicable particularly to provide the social security measures to the different employees, those who are belonging to specifically organized sectors. It is a lump sum payment made by an employer to an employee in consideration of his past service when the employment is terminated. So, whenever any kind of employee, those who are going to be retired, okay, maybe due to superannuation, okay, this is the kind of act where the individual employee will be get benefited by means of using that social security benefits. So this act will be a form of social security measure to the employee, and whenever that employee is going to be retired, okay, that employee will be get the benefit under this Payment of Gratuity Act 1972, and he will get some lump sum amount to protect their individual lives, okay, after the retirement. So when we are talking about this kind of law or this Payment of Gratuity Act 1972, this payment of gratuity has been paid on the basis of the how much would be the length of service in that particular establishment. So generally it should be counted on the basis of, okay, how much service that he has been made. So it should be considered that the employee must work continuously within that organization, okay, or they are in the continuous service. Employees, those who are being automatically retired, okay, due to its superannuation, or they are taking the advantage of the scheme, okay, voluntary retirements, okay, even these social security benefit or payment of gratuity would be applicable to all these employees. If any of the employee, those who can died, okay, and that employee will be liable to get the benefit under that Payment of Gratuity Act, okay, wherever it should not be considered the length of service. So gratuity is nothing but a lump sum payment made by the employer to that particular service as a form of recognition of the service rendered by that particular employee, okay, when he retires or leaves that particular service. So how much total service that he has given to that particular organization, depending on that gratuity will be calculated, and finally it should be given as a form of recognition to that particular employee after the retirement or once the employment has been terminated. When we are talking about such a kind of the social security measures, we will already discuss about that our um, act that is called as the Provident Fund Act. That act will also provide the social security benefits to the individual employees. But to protect specifically after the retirement, okay, so that after retirement life can be get protected, okay, by means of using payment of gratuity act. So in case of employment coming to an end due to retirement or maybe due to supervision, it enables the affected employee to meet with the new situation, which quite often means reduction in earnings or even total stoppage of earnings. So whenever the employee is going to retire, okay, so they will be completely exposed to the new environment, okay, after just the retirement of that particular employee, and there will be reduction in earnings. He could not earn after the retirement, or there may be total stoppage of earnings. So in that case, okay, it is quite necessary to protect these employees specifically after the retirement, and wherever we are focusing by means of using that payment of gratuity act. So after retirement life can be get protected using the PGA Act 1972. In case of death of an employee, okay, it provides much needed financial assistance to the surviving members of the family. Even this kind of benefit, payment of gratuity, can also be made to the employee if the person has been deceased during the course of employment. Okay. So if any person died, okay, within the year also, that person could be also be entitled to get the benefit under the PGA Act 1972, and specifically their family members can be get protected, okay, and some sort of financial assistance can be provided to them. Gratuity schemes, therefore, that can be served as an instrument of social security measures. Okay, so this has been quite helpful to the individual employees, those who have been continuously in service and render this service for that particular organization. Now it is the duty of that particular employer. Okay, so they need to provide some sort of financial assistance. Okay, and it is the right of the employee, so it should be given in the form of recognition. And specifically we are talking about, suppose say, Indian context, okay, say for example a developing country, okay, wherever the income level is quite low, such kind of social security measure in the form of gratuity, which will be definitely helpful to the employees, those who are being going to be retired, okay, and after retirement this gratuity would be helpful to them to protect their individual lives. Applicability of that payment of gratuity act 1972. Now this act has been primarily applicable to those employees, okay, those who are being entitled to be defined as an employee under the PGA Act 1972. Okay, act enforce the payment of gratuity. Okay, that gratuity is nothing but called as a reward for long service, okay, as a statutory retirement benefit. Okay, so it is a form of reward for a long service that he has rendered to that particular organization. He has or she has rendered, okay, to that particular organization. So it is the duty of the employer of that organization to, okay, provide this reward in the form of gratuity as a form of statutory retirement benefit. So every employee, irrespective of his wages, is entitled to receive the gratuity if he has rendered continuous service of 5 years or more than 5 years. Now it is a specific condition, okay, particularly for all the employees. Okay, if the employee has rendered nearly, suppose say, 5 years continuous service or more than 5 years continuous service, the employer would be liable to pay, okay, the gratuity in the form of reward, okay, to that particular employee. It is not paid to an employee gratuitously or merely as a matter of boon. It is paid for the services rendered by him to the employer. Okay, so in in case of certain organizations, okay, those who are not paying the such a kind of gratuity as a form of reward, okay, depending on the length of service of the that particular employee, okay. So generally that organization should not have to pay the employee gratuitously or merely a matter of boon. It is the right of that particular employee, okay, whatever the will be the length of service that he has given, okay, to that particular organization, okay, it should be paid in the form of reward by his employer, okay. So it is not just a matter of boon, okay. A payment of gratuity act provides the payment of gratuity to the employees engaged in factories, mines, oil field, plantation, ports, railway companies, shops and other establishments and any other matter connected therewith or incidental thereto. The act is applicable to the whole of India. Now, when we are talking about the applicability of this act has been applicable almost in all the organizations, okay, different types of establishment, whereas they are factories, mines, oil field, plantation, ports, railways or even shops also and any other related establishment, okay. So this act has been extended to the whole of India and whatever form of industries has been covered that has been mentioned in this act. Now, when we are talking about how much would be the total gratuity that the individual employee that they will receive after the retirement, okay. Recently, the act has been amended, okay, twicely, okay, and hence enhanced the ceiling of amount of gratuity. Earlier, the total gratuity amount was 10 lakh rupees, and it has been increased to 20 lakh, okay, depending on the length of service and simultaneously which particular type of employee that should be covered under this act, okay, that has been mentioned even in section 2e of this uh, payment of gratuity act 1972. So it was quite beneficial to the individual employee, particularly after the post retirement, so he can meet, okay, all his contingencies and save their individual life and protect their family members with the help of such kind of gratuity as a form of reward from the employer. Now when the gratuity has been payable, okay, now there will be three basic conditions on which the individual employee will be liable to get the benefit as a form of gratuity, and that is to be paid by an employer. So according to section 4.1, okay, of payment of gratuity act 1972, that gratuity has been payable to the employee on the termination of his or her employment. So whenever the employee is going to be terminated, okay, or suppose his term has been completed or he has been retiring on that specific date, okay, he has rendered the continuous service for not less than 5 years. If any of the employee, those who are being going to be retired, okay, after giving the continuous service of suppose say 5 years, okay, that employee would be liable to get the benefit as a form of payment of gratuity on his superannuation, okay, on his retirement or resignation. If the employee has given the resignation or the employee is going to be retired, on his death or disablement due to accident or disease. If the employee has been died due to accident or any occupational diseases or any sort of permanent or partial disablement, okay, permanent disablement, okay, means the employee could not be entitled to work in the factory, okay. So in that case, that particular employee will be liable to get the benefit as a payment of gratuity from the employer. Now when we are talking about the completion of that continuous service, okay, which should not be less than 5 years, okay. So there is some necessity conditions, okay. It is necessary here the termination of the employment by an employee due to death or disablement, okay. In case of death or disablement, okay, that may be occurred due to accident or disease, okay. So if any of the employee, those who died due to disablement, okay, due to accident or diseases, okay, there will be no problem, okay, or there will be no condition of continuous service of 5 years, okay, and the employee will be get benefited over here. So in this case, we could not look over here whether the employee has been in continuous service for the 5 years. So minimum requirement would be, okay, there should be is said to be followed. The employee should be in service, or during the course of employment the employee has been died, okay, or minimum 1 year length of service would be considered over here. For the period of continuous service to be revoked from the date of employment, okay, not from the date of commencement of the act. So since when that particular employee, okay, he has been in the course of employment, okay, and from which the continuous service has been calculated. So whether the employee has been in continuous service or not, okay, that should be specifically taken into account on the superannuation or on his retirement or resignation. Okay, if the employee died due to disablement or due to accident or diseases, okay, there will be no problem of continuous service of 5 years. In other two cases, it should have to be identified whether the employee has been in the continuous service of 5 years. Now, the definitions under this PG Act 1972. When we are talking about the different kind of employees, okay, those who are being entitled to get the benefit under the uh, Payment of Gratuity Act 1972. So, according to Section 2E, okay, employee means what? Okay, employee means the any person other than apprentice, means apprentices are not covered, okay, in this act, okay. So apprentice means the employee, those who are on the probation basis or those who are working for on the training period, okay, they are not entitled to get the payment of gratuity benefits. So any person, those who are being employed on wages or in any establishment, say for example factory, mines, oil field, plantation, port, railway, company, shop, okay, and those who are being performing any kind of work, maybe those who are being skilled or semi-skilled, unskilled, manual, supervisory, technical, or clerical work, okay, or whether the terms of employment are being expressed or implied. So these kind of employees are being covered under this act. And whether or not such person is employed in the managerial or administrative capacity, but does not include any such person who falls under the central government or state government and is governed by any other act, okay, by any other rules providing the Payment of Gratuity Act, okay. This act could not be directly applicable to certain kind of employees, okay, employees those who are being working as on the managerial or administrative positions, particularly under the central government or state government, wherever, okay, they are being governed by certain other regulations of the state or center, okay, they will be covered in some other acts, okay, and they will get the benefit of this act. Continuous service. A continuous service means an uninterrupted service for a period of 5 years minimum, okay, that should be specified under section 2A. So under the section 2A, okay, how much will be the length of service of that particular employee, that need to be calculated very appropriately using the different clauses. So, an employee shall be said to be in continuous service for a period, okay, if he has for that period been in uninterrupted service. So, any employee, those who are being rendered his continuous service, that continuous service must be an uninterrupted service, including service which may be interrupted on account of sickness, okay, maybe due to certain sort of sickness, accident, leave absence, from duty without work, not being absence in respect of which an order treating the absent as a break in service has been passed in accordance with the standing order rules and regulations governing the employee of that establishment. Also, layoff, strike, and lockout or cessation of work not due to any fault of the employee, whether such uninterrupted or interrupted service was rendered before or after the commencement of the act. Now let us see what exactly means the continuous service. A continuous service means an uninterrupted service including due to whatever leaves that he has been taken, due to suppose say sickness, accident, leaves, absence from duty without work, okay, whatever form of leaves has been considered, okay, but it should be considered under the continuous service, okay, and whenever he has taken the leave he is on the role of that particular employer. Not being absence in respect of which in order to treating the absence as a break in service has been passed in accordance with the standing order. Okay, if the employee has been showing as an absence, okay, and has been treating as an absence as a break in service, okay, so absence as a break in service has been shown, okay, and for which it has been mentioned under the standing order or any rules and regulation governing the employees of the establishment, then and then only, okay, the continuous service, okay, then and then only the employee would not be treated as in continuous service. So here most of the employers that they will take some undue advantage and they are not showing the employee as they are in the continuous service, okay, but in most of the establishment that the establishments are taking some undue advantage, okay, over here. It may be due to even also layoff, strike, or lockout or cessation of work not due to any fault of the employee, whether such uninterrupted or interrupted service was rendered before or after the commencement of the act. So, if suppose any sort of lockout, layoff, strike, okay, which has been declared, okay, either by the employee or suppose say the employer, okay, work not due to any fault of the employees, okay, it should not be considered as a fault of the employee, and the employee will be treated as in continuous service. Whether the employee not being an employee employed in seasonal establishment, okay, and is not in continuous service within the meaning of the clause, means employees belonging to the seasonal industries, okay, or seasonal factories, okay, there is a minimum condition, okay, the clause 1 would not be get applicable for seasonal establishment. For any period of 1 year or 6 months, okay, he shall be deemed to be in continuous service under the employee. So, in case of seasonal industries or establishment, the employee must be in continuous service, okay, not less than 1 year. So that is the minimum criteria for continuous service, okay, in case of payment of gratuity act 1972. Now there are some other conditions which has been mentioned under the payment of gratuity act 1972 as a form of continuous service. So there will be two clauses, clauses A and clauses B, and these two clauses has been specified with certain explanation. Now these are all kind of rules and regulations and which can be applicable to all the employees, and so that its total continuous service, okay, or number of service days will be calculated, particularly when they will liable to get the gratuities. So for the period, for the said period of 1 year, the employee during the period of 12 calendar months preceding the date with reference to which calculation is made has actually worked under the employer for not less than, okay. So whenever the employee has been rendering their services, okay, particularly for the 12 calendar months means 1 year preceding the date with reference to the calculation can be made, okay, has actually worked under the employer for not less than. So minimum criteria, okay, for to say the employee would be in continuous service. So in one case, first case, we will see, okay, 190 days means 190 days in case of employee employed below the ground in mine, okay, or any other establishment, okay, with work for less than 6 days in a week, okay, wherever the week is being 6 days per week, okay. So under mines specific kind of industry, okay, 190 days of continuous service, okay, including leaves, okay, will be counted. 240 days, okay, in case of other industries excluding mines, okay, rest of the other industries wherever employee would be in continuous service for minimum of 240 days means 240 days for the said period of 6 months, okay, wherever there is a 12-month calendar working, okay, and wherever there is a 6-month calendar working, okay, in case, okay, how much would be the total number of days wherever the employee should be in continuous service. So wherever there is a 6 month, okay, the employee should be of minimum 95 days, okay, in case of employee employed below the ground in mine or in any other establishment, okay. So in case of specifically mines and other industry, there is a different criteria, 120 days, okay, wherever the nature of working would be for suppose say minimum of 6 months. So in case of mines, there will be 95 days, and in case of other industries there will be minimum of 120 days of working would be required to say that employee should be in continuous service. The explanation of these provisions are for the purpose of clause 2, okay, the second clauses, okay, the number of days on which the employee has actually worked under the employee shall include the days on which, okay, there will be some different provisions to say that employee would be in continuous service specifically in case of clause 2, second clauses for 1 year working, and second clauses specifically for 6 month working. If he has been laid off under the agreement or as permitted by the standing order made under the Industrial Employment Standing Order Act 1926, okay, or under the Industrial Dispute Act 1947, or under any other law applicable to the establishment. So that total number of days, okay, excluding mine, the second clauses can be explained, and wherever, okay, during the case of laid off, okay, it should be look after whatever has been specified in the agreement or in the standing order, okay, covered under the Standing Order Act 1946 as well as Industrial Dispute Act 1947, okay, or any other connected law which has been applicable. So depending on, okay, either 240 days or 140 days cases, so that particularly what would be the total working days are required for continuous service, okay, that should be calculated on the basis of whatever provisions has been made under the Standing Order Act and Industrial Dispute Act. He has been on leave with full wages earned during the previous year. If the employee has been on leave with full wages, okay, earned in previous year, maybe due to suppose say medical ground or something else. If he has been absent due to temporary disablement caused by an accident arising out or in the course of employment, okay, so whether he is on leave or he will be having some problem with respect to temporary disablement, or in case of female employee, okay, she has been on maternity leave, okay, total period of such maternity leave does not exceed the 12 weeks. So any employee, those who are being entitled to get the benefit of that payment of gratuity act, and they will be, suppose they were taken any advantage of these provisions, okay, they will be also considered as they are in continuous service. Whether the employee employed in the seasonal establishment, so any employee those who are being employed in seasonal establishment is not in continuous service within the meaning of clause 1, okay, for any period of 1 year or 6 months. Okay, there is a criteria that if the period of 1 year or 6 months, he shall be deemed to be in continuous service under the employer for a period he has been actually worked for not less than 75% of the number of days on which the establishment was in operation during such period. So particularly in case of seasonal units, that minimum criteria of total working days, okay, if the total working days is suppose say 50, okay, out of which, okay, nearly 75% of number of working days are required to say that the employee would be in continuous service. So nearly suppose say 50 days working are supposed to be there, so 30-35 days will be considered, okay, in case of seasonal industry as a form of continuous service. The next definition under this act is called as controlling authority or appellate authority. Okay, so this kind of act has been primarily governed by some two important functionaries, okay, or these controlling authorities and appellate authorities, those are the prime authorities under this act, those who look after the administration of this act. So under section 3 of this act, appropriate government has been notified according to the official gazette, okay. The controlling authority will be responsible for the administration of the act. So complete payment of gratuity act and its administration will be under the control of that controlling authority. So controlling authority will look after each and every aspects of this act. Okay, so different controlling authorities may be appointed for different areas. So in different areas there will be different controlling authorities, maybe on region to region basis. According to section 7 subsection 7, provide the appeal being preferred against the order of the controlling authority and appropriate government and other such other authority may be specified by the appropriate government in this behalf. So according to section 7 subsection 7, okay, if the individual employee are being not satisfied, okay, the individual employee will appeal to the appellate authority against the decision of the controlling authority to the appropriate government, okay, whatever provision has been made by the appropriate government. So in this way the overall administration and appeal function would work in this act, okay, payment of gratuity act 1972. Okay, so that's all about our today's session. Thank you very much.